What's up, everybody? Welcome into another episode of The Lawyer You Know. Will this be the last day of Karen Reed trials? Will we have a verdict today? It's kind of been our guess from the jump. It just kind of made sense. Wasn't going to happen Friday. Take the day Monday, come back and finish it up today. Will we have a verdict today? We get a pretty good indication from three juror questions that we're going to listen to the lawyer arguments, which is also telling the demeanor and way the lawyers are arguing and what they want to be told to the jury as answers, incredibly important. The judge gives those answers to the jury, calls them back into the courtroom to give them those answers, which is also interesting in its own right. And then the jury is sent back out without a verdict at this point. But we are going to break down those juror questions. My dad is going to join me later on, give us his thoughts on the juror questions if you had a chance to take a look at them, answer your questions, and maybe we'll morph this into a verdict watch. We'll see. Make sure you guys hit that like button. Let's get to it. So we were hit with, some of the most important things that can happen in a case is juror questions. I love juror questions. I love more information. I want to put it all into the computer and then see what it spits out, see how we can analyze it. It's not all or nothing, but it can definitely give us indications. I always tell you in my trials, my favorite question from the jury is, can we get a calculator? Because that usually means good things for our case and our client. And just you can learn so much information from juror questions. And we knew what some of the push points in this case are going to be. Can we tell whether the jury is thinking about intent? That was a big one in the first trial. It's not as big this trial. Can we tell if the jury is talking about a collision? Did a collision happen or not? Is the jury focused on Karen Reed's own words? Are they confused with count number 2's verdict slip? Those are some of the points that we knew could be an issue. And looking back now at these jury questions, we were right. So let's take a listen now to the jury questions. Then she's going to give the lawyers a break and some time to talk about it as she should and come up with their arguments and what they think the answer should be. We'll talk about why a judge does that, why lawyers don't just answer immediately. But first, let's hear what those questions are.
They appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them.
By the way, in case you didn't know, the court is on break until 1:30. That's when we were scheduled to start this video. Hopefully my dad will come in around then to answer a bunch of questions and kind of go through his thoughts on these jury questions as well. But we're first going to sit here and talk for a little bit about these jury questions. I really wanted to get to them, and I think we might have a verdict pretty close to 1:30. So I really wanted to talk about these because they were such an interesting part of this trial.
What is the time frame for the OUI charge? Offense 002, Section 5. OUI at 12:45 or OUI at 5 a.m.?
When was Karen Reed driving drunk? At 12:45 or 5 a.m.? How could she be driving at 12:45? Right? Don't we have voicemails and connecting to Wi-Fi and being in John's house? That's the evidence that was presented to this jury. Now, if it's 5 a.m. and she's out driving again, then I can see how the jury's getting there. But if the jury comes back not guilty on OUI because they think it was 12:45 and everybody's timeline proves she wasn't driving at 12:45, if that was the only question, I'm thinking as Karen Reed, like, holy crap, they're all the way to OUI. That's good for me, number one. And number two, if they think about 12:45, how is it possibly guilty? Because I was not driving at 12:45. So that should be not guilty. Easy. We'll see how they end up answering it. What's question number 2?
The second, are video clips of Karen's interviews evidence? How can we consider them?
It's not as good, right? Because we know the defense did not play any clips to add context. So any of the clips they're talking about are from the Commonwealth's case. And that's not good. And in conjunction with the OUI questions, we know she said some things about drinking and driving. So we have to be careful. If the jury's really focusing on her statements in conjunction with the OUI, does that make them lean more toward guilty of OUI potentially?
And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
And that, so folks, is the big question. Does voting guilty, for example, on the 5th lesser included, which is OUI, does that create a scenario where she's guilty of the entire count 2 charge? What does that tell you? Well, that tells you they're confused with the count 2 verdict form. They're confused with what boxes they check and what they don't. And because there's only one not guilty box, which again is not abnormal. Don't get it twisted. I'm not saying they're the only ones that do this or anything like that at all. We said it when we broke it down in the last verdict slip. But it would be better. It's not a wrong answer. It's not a wrong verdict form. But there are better verdict forms. And this is one of the reasons why. They're confused that if they check guilty here, there's nowhere for them to check not guilty for the first 4. So do they think a guilty here means guilty all the way up the board? Clearly no. And if they knew exactly what the words meant and why we put the semicolons and the periods and the commas and the places that we do on the verdict form as lawyers. So Kelsey just texted verdict just in case John to help. And I was like, what? There's a verdict? First word was verdict, and I literally jumped a little bit. Okay. So very, very important that all indications are pointing to the jury is deliberating over OUI. You would only get to OUI if you were not guilty, not guilty, not guilty, not guilty, not guilty, multiple not guilties to get to OUI. But OUI is the same thing as DUI. But if there's nowhere for them to check the boxes, what's going to happen if they hang? Are they going to have to retry her on everything, on just count 2? How is it going to work? All of those questions remain open. Let's hear how the lawyers argue they want to answer these questions to the jury. Another question coming at 1:30, somebody said. Well, we're going to be ready. We'll be done with our juror question conversation by 1:30.
So I will give you some time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for.
I'm going to jump ahead then when we get to the lawyer arguments. They take a break, they come back, and now we hear the lawyers are going to argue what they want the judge to answer those questions. And something I found most interesting about this is it seemed as if, a lot of times the judge has been in lockstep with Hank Brennan, right? On how she thinks she's going to answer these questions. She's like, well, I know what I would cut out, et cetera, et cetera. But in this conversation, I start to hear her and Attorney Jack say, yeah, that's what I was going to say. Yeah, I agree with that, Judge. Yeah, I was thinking the same thing. Seemingly more in lockstep with the defense on how to answer some of these juror questions. Will Hank Brennan change her mind because he's got an argument on every single one?
Do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge? Offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Finishing each other's sentences, some would say. You're the fact finder. And by the way, I would agree with that. And most of the time, you want a simpler answer to the jury. You don't want to give them any more information. You don't want to sway them one way or the other. The lawyers will sometimes try to argue to sway them one way or the other, but generally speaking, especially as the judge, you really want to give as neutral as an answer as you possibly can. And that's about as neutral as it gets. You guys are the fact finder. You determine the facts. Brennan doesn't agree with that.
Mr. Brennan, or whomever from the Commonwealth?
My suggestion would be 12:45.
And why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
He says he wants 12:45. He's kind of hard to hear, so I'm just going to repeat it. He says he wants 12:45. That's always been the time the case has been focused around. I don't disagree with him, but that's not how it works. And by the way, I think 12:45 is bad for him.
Do we have the indictments?
No.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we can pull that up.
So everybody seems to be on the same page. We can't tell them unless they said at or before, at or upon 12:45 a.m. on this date, Karen Reed was driving. It's because nobody was planning on OUI necessarily. And we'll see if it ends up being it's an amazing strategy for the defense if they come back, obviously all 3 not guilties, but if they come back on just guilty on OUI, amazing strategy by the defense. Listen, peel back behind the curtain. They don't want to lose, but this would be a win. This would be a 100% home run win because guess what? If it's guilty on OUI, all the smoke about the conspiracy and no collision and We know who really did this, et cetera, et cetera. All those conversations are still open. They prove no collision to this jury. This jury agrees with them. We're not jumping the gun. That's not the verdict. But if it is the verdict, the defense is going to get a lot of runway with that. A lot of runway. The OUI charge, Karen Reed would probably admit she had too much to drink. I mean, she basically did on some of those videos. Now, you can still fight it. And if this was just an OUI trial, you would have seen a very different defense. They would have been picking apart how the blood was taken, how the extrapolation worked, when she was actually driving, if she had anything else to drink at home. It would be a completely different trial. Trust me on that. This would also be the most expensive and wasted money on a DUI trial of all time. I once had a 5-day DUI trial that ended in a hung jury, and then we thought we were going to have to try it a second time, but they ended up dropping it down to a reckless driving. I thought that was the most expensive DUI trial that I was ever going to see because it was expensive. There's a lot of experts and stuff in that case too. It pales in comparison to this case. Pales in comparison.
There's no time. I don't expect that there's any time.
All right, so I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight.
So somebody said Brenton said 1235, not 1245. That would be even weirder if they gave a different number than what the jury was even asking about. But 1235 obviously makes a lot more sense for the Commonwealth side.
You think is appropriate to give them, and then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you.
And she has no problem with that. He agrees with what she was going to instruct. Give them whatever evidence, whatever weight you seem necessary. He said, if any. She's like, sure, that makes sense. If any, we know all the jokes about it, if any, and in this case. And she's in lockstep. Once again, judge seemingly agreeing with Jackson. But does Hank Brennan agree?
Otherwise, it's fine.
What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case to say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so
he argues basically you should say weigh it like every other piece of evidence. He doesn't want to say the if any, obviously, and he wants to look at it as if it's any other piece of evidence in this case. What do you think Judge Cannoni is going to do? Who is she going to agree with? It seems like she already agreed with Jackson. Did Hank Brennan change her mind? Brian said, vacationing in Tahoe, wearing my lawyer hat. I'm waiting on a verdict before jumping in the water. How dumb is that? I'd probably be doing the same thing, Brian. As embarrassing as that is, I'd probably be doing the same thing. Patio, Peter, I was watching one of your old videos last night. You were talking about getting a perm when you hit 500,000 followers. Well, I do not. I cannot be held responsible for anything I may have said in the past. I do not remember that. Amy, the instruction about the time frame is the right one. You have the evidence. What did the Commonwealth prove to you? I agree. Don San Juan, if they find her guilty on the OUI charge, do you think it's worth an appeal? Potentially. Somebody else asked, if guilty on OUI, you think she'll give the max sentence? No, if she really wants to like screw Karen Reed, she'll give her like 30 days or something, which sucks and is harsh for a first time DUI or OUI. It can go up to 2.5 years. I'd be shocked. That would show obvious bias. It's a first time. The jury found it did not result in death. So you can't give those kind of harsh penalties as if it did result in death. So that's kind of how I would see that playing out. Morgan, Peter, is it a W for the defense if they only convict on OUI? Will she serve time? Also, can you shout out Tanya Boyce? What's up, Tanya Boyce? Shout to you. I think it's a major win for the defense because, again, they bought all their arguments. They barely argued against the DUI. Again, I think it comes down to Karen's own words and some of the video evidence they have. It is what it is, and you shouldn't drive drunk. And if she gets convicted, her normal penalties should not include jail time. It really should not. Will Judge Canoni try to do that? Maybe she'll try to get a supersedious bond, which is like a bond that you get during your appeal. So you're out. And when you have a short sentence, sometimes they're even quicker to do that, but I don't know how long the turnaround might be. They take her to jail right away and it takes a week to file the supersedious bond. Then she sits in jail for a week. So there's all sorts of things that can come into play if she is given any jail time, which I think is possible, but it should be highly, highly unlikely. All right, let's see what Judge Canoni decides.
Responsibility that they have. Every single evidence is given the weight it don't have to give it.
She's doing a little looking. Gonna skip all this.
First, then I'll go and I'll read the, would any other.
All right, here's her
All
decision.
right. So what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, then I'll go and I'll read the electronic communications and the humane practice. That covers it.
I don't have a principled objection to it if the court adds the word "if any,"
I understand.
because every single
She's like, I understand, and I'm not going to. So she basically, I thought she was going to do a little combination. It was vast majority of what Hank Brennan wanted and removed the if any, which I don't understand why she'd remove that, but she did. So Hank Brennan convinced her.
I don't want them to think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they can weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it all together and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that
And this argument is not successful. She sticks with what she said, and his rights are protected.
Third one.
And now we get to the big one. This is the big one.
Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could.
So they have an amended verdict slip that we can't necessarily see here ourselves. I don't know if anybody has that, but we don't have that verdict slip. Number one, they're reviewing it. Mr. Jackson thinks it answers most of their questions. We'll listen to a little bit of their back and forth, but we're going to come back when the jury comes in to hear exactly how Judge Canoni reads it to the jury. I want to make sure we're done with all of this and I can answer these questions all by 1:30. The jurors referring to her as Karen speaks volumes. You know what, Western Mass attorney? Shocker, you're an attorney, I think. I wrote the same thing down. If I was the defense, I'd be like, oh, she's Karen, not the defendant. Because they made a big deal about that in this case. A big deal about that with multiple witnesses.
Say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge,
Somebody said it's on X, tag me in it, and I'll try to pull it up.
example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps we could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002, number 5, is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And I'm happy to go over those with you and put those on the record.
Go ahead.
With regard to going from the top to the bottom, just under number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the language, the consistent language that it's added throughout the verdict slip. If you, quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period.
We're going to just skip ahead. I'll hear what Hank Brennan says a little bit, but we're going to get all the answers when she actually reads it to the jury to see, is it less confusing?
Instructing them on the nuance of selecting one guilty or not guilty. I don't know. It needs to be explained. I think with the edits, this proposed instruction explained it. Yes.
All right.
All right. So here comes the jury. Back in. Here are the actual answers Judge Canoni gives them. And this is what they're walking back into the jury room with. And this is what they're going to go and continue to deliberate.
Sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question.
So now the third question. The first two are kind of simple. The if any would have been nice. Not that big of a deal, I don't think. Gringa said, so the jury forced Bev to do what the defense wanted. Not quite. It's not quite their verdict form, but it's better and it's getting closer. And you'll hear exactly how this is broken down for her. Riri said, can I get a shout out from my boys? One says guilty, the other says not guilty. They love you. And one wants to be a defense attorney. Shocker, he's the one that says not guilty. This weekend, a gal came to my yard sale and was showing me her arm that was bitten by her neighbor's dog, and it looked very similar to John's arm. If I was a juror, could I come back and tell other jurors and use that? So you are not supposed to go and do any other research. That could be considered any other research. Now, what you can say is you can bring your experience into it and be like, I've seen dog bites before. This looks like a dog bite, which goes in line with what Dr. Russell and La Posada and all these people said. So those are the kind of the nuances. Can they only convict on OUI if they take Karen's own statements as evidence? They are into account at 12:45 because she never drove after. BAC tested at 5 a.m. Not guilty because she should have drank more at home. So I don't think I think the timeline's a little bit off here. I think she was tested even later. 5 a.m. She said she got back in her car and went searching for John. So that could be her driving at that point. A lot of it would have to do with her own words. If they choose to appeal on OUI, do they have to stick to evidence directly related to that charge? They have to stick to the evidence in this case, and the only one that would be relevant to that charge would be the evidence directly related to that charge, so most likely. If Karen Reed is convicted of an OUI, will that affect her ability to sue the Commonwealth for malicious prosecution? Thank you, lawyer. Makes it a little bit harder, but not overall, because she could say, I never denied that, right? I mean, I guess she did deny it because she argued against it, but I would have pled to that. If it was just a DUI, I would have pled to it, but they covered up and did all this, whatever conspiracy and planting and whatever she's going to argue for a malicious prosecution, all has to do with the collision and the death of John O'Keefe. So I think she would still have an argument there. All right, let's take a listen to how Judge Cannoni, that's the human practice jury instruction that she read. And that's the one that we read through as well if you go back to our jury instruction video.
Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit.
One thing this could also do, Ashley said, what are your overall thoughts? I've been giving my overall thoughts kind of throughout, but one thing this could do is we could have a verdict pretty quickly, or it could give the jury the understanding that, oh, we get real answers to some of these questions we ask. So some of the other questions we had back there, maybe we need to write down some more questions to get more clarification because she gave us a new verdict slip. That's a big deal. So maybe we have a question on something else. Maybe she'll give us another document to fully explain it better. It's potential that, the jury's mind kind of change as to what they can actually do and accomplish here.
Easier for you to follow. And for purposes of going through this, we'll go through it together. And I've got a copy for each one of you. Okay.
All right, they're passing them out.
So you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, Then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence.
They've added more verbiage to each individual section. Okay. By the way, if anybody sends it to me, let me know. If you message it to me on Twitter/X or Instagram, and I'll try to pull up the new edited verdict slip.
Of liquor, then continue below to the lesser included offense. And first under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI, liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence.
So you don't go down to OUI unless you find them not guilty of the higher charges. Now, it would have been better if she said no, right? If we find her guilty of OUI, is she guilty of the whole count too? It would have been better if Judge Cannoni would have just clearly said no. That's not what it means. You would just convict her of OUI. I don't know why no one pushed for that. I don't know if it happened at a sidebar or something outside the presence of the cameras, but that's my perspective. I would have liked that additional little tidbit personally.
And you check one or both of the following: operating a motor vehicle under the influence of liquor, and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to...
So then she says, does that make it any clearer? Hopefully, which I found to be pretty interesting as well. I'm trying to look at the one I had before. I know I had the old verdict slip, which I don't even know where it is now. But I would like to compare them side by side. Which I guess what we could do is pull up the old verdict slip and compare it to her verbiage. But let's listen to what else she tells them.
Send you back out. Sure, why don't you come on over?
All right, so they're going on sidebar there. I know I have it. No, I can't find it. I hate when that happens. I think this is when
Felony OUI liquor. If you find the defendant guilty...
makes a correction. So she makes a correction here, which I thought was important because she's like, I don't remember if I said this right or not. Kind of like confusing herself a little bit. So we'll see what she has to say.
Counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay. Thank you very much. We're going to release you.
All right, the board, please. You're voting.
All right, so I'm going to back it up,
Guilty of the lesser below. If you find her not guilty,
and I'm going to pull up. Let me show you here. This. So here is count 2, what it looks like, and what the jury started with. Okay. So, and then we're going to get to some of the differences. So they have each of them guilty, right? And then you work your way down, is what she said. Now they've added in all of this verbiage that says, if you find not guilty of this one above, then you work your way down. Okay. So you have a look at this one. I don't think I can put both of these up here at the same time, can I? I don't think I can. So here we go. Okay. So you see all of these, and then we'll listen to just how she kind of explains the last one dealing with the OUI, that she makes a correction, but you get the point as to what was added in.
guilty of motor vehicle homicide, OUI, liquor, and if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think
that is what is not included in the current verdict slip. If you find her not guilty, then continue below. That's the important part. That's what the defense wanted in there. Guess what? The defense's verdict form would have completely dispelled these issues. These issues would have been gone.
Of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay. Thank you very much. We're going to release you.
All right, the board, please. You're voting.
All right. And I'm going to put this on in the background so that you guys don't have to hear it. And we can make sure we hear if anything comes back for a verdict. I think my dad is about to be on soon. We will start asking him about the jury questions, and then we will get to your questions. I think he's got about 30-ish minutes to hang. Question, do you think if she gets the OUI that the Commonwealth will give her the max, even though it's her first offense because they lost the rest of the charge? They can ask for whatever they want to, but it's going to be up to the judge. All right, I see my dad is joining us. Hello.
Hello.
Oh, you got the jail bars in the background. That's good.
Oh, yeah, well, you know, your listeners would. There's a long story, as you know, for my office on the outside of the house. So.
Yes. It is the outside office where he's allowed to smoke cigars because he's not allowed to do it anywhere near the house.
Because I've got my own air conditioning system out here, so.
Exactly, it's like a wall unit. It's
Right.
it's something special, that office. It's got roaches. It's disgusting. We hated going in it as kids. It's like the worst office ever. We hated it. We hated it. I distinctly remember never wanting to go in there, literally, when I was little. But it's very safe, as you can tell from the jail bars on the door. So a lot has happened here, Dad. I know you have about 30 minutes with us. So I want to start by talking about some of the jury questions. The jury had 3 questions today. I don't know if you've been able to see them at all.
I have. I've read them and I've looked at them. Yeah, and I've watched the judge. Yeah. Okay,
so let me recap them for you real quick, and then you can give us your thoughts. Number 1, is the time of the OUI that we are supposed to consider 12:45 a.m. or 5 a.m.? Number 2, are Karen Reed's video clips evidence? And if so, how should we weigh them? Something like that. And then question 3, if we wanted to convict on a lesser included of count 2, like OUI, number 5 on the lesser included, would that convict on the entire count? So let's start with question number 1. What are your thoughts there about what the lawyers argued and what the judge ended up answering the question on about the timing of the OUI?
I don't think anybody thought about arguing that she was drunk driving at 5 a.m. I mean, I don't think anybody, but I think that, we've always said jurors find stuff and think of stuff we never think about. And what they're saying is maybe she wasn't drunk at 12:32, But you know what? Maybe she was drunk at 5 a.m. when she drove back there. I mean, that's obviously what they're thinking is, can she be drunk at other times other than 12:32? And who in the world would have said, maybe they're thinking of other times for the DUI? But obviously that's a good question for the defense.
Well, I'll tell you right now, the defense, there was not a lot of planning around the OUI. Okay. There was not a lot of planning. It wasn't lesser included last trial. They didn't try to pick apart the extrapolation like we would always do in a DUI trial, the blood draw, the issues. Did she drink at home? Jackson kind of made that argument in closing, but in a real DUI trial, I think they had a lot of arguments against it that they didn't really use. And Karen Reed's own words are going to kind of hurt them when it comes to the DUI. We both throughout the trial felt like, she was probably drunk driving, right? Is that enough beyond a reasonable doubt? Maybe not for this jury, but usually jurors looking at the evidence before them would say yes. The issue at the time is the Commonwealth's original plan and theory was 12:45 when Lally started the last case. That's what the extrapolation person said, that they were extrapolating it back to 12:45. They didn't even extrapolate it to 5 a.m. I can't remember if they did or not, but that was a problem in the Commonwealth's. Go ahead.
But there was argument that how do we know she wasn't drinking after she got back to the house? You remember, they talked about that. So if she was drinking back at the house, then she'd be, and then of course they've got the telephone conversations, which she sounds pretty drunk on those telephone conversations.
The voicemail?
So, excuse me?
The
voicemails.
Yeah.
The voicemails. Yeah, she sounds pretty drunk.
No, I agree. And I think that, Kelsey, you can throw up a poll for OUI, guilty, not guilty, or hung jury. But from my perspective, the reason 12:45 is so important, she's back at John O'Keefe's house. She's connected to his Wi-Fi. She's walking inside. You hear her heels clicking. So if they're really looking at 12:45, they don't have a wheel witness to prove she was driving at 12:45. So I think that could be a not guilty. I think the 5 a.m. is probably the more likely guilty one based on their extrapolation if you think about what it would have been at 12:45. But this just so confusing. And like I said, if they would have spent the entire trial fighting the DUI, they might have had a good fight. The way they put it out there, what are your thoughts as far as the defense thinking, oh no, they might convict her on the OUI?
First off, let me say, it's something we haven't talked about because we're sitting here talking about evidence. What we haven't talked about is a compromise, and the fact that we've got to convict her of something. A lot of some of the people said, "Look, all right, we'll convict her of the DUI." Okay, everybody, those people who want guilty, those who want not guilty, can we agree on the DUI? That's a possibility back there, is that DUI is a compromise decision. I think the odds are real good on the DUI after that question. It is such a serious question to talk about a timeline for the DUI that I think the odds are real good that they're actually looking to convict her of DUI.
And that would be kind of crazy because like our chat, we've been doing these polls, and every other time we've talked about guilty, not guilty on the other charges, it's like 85% not guilty. And then the either guilty or hung jury is like a small percentage. But with the OUI, I think it was yesterday, I can't remember, Kelsey, it was like 50% not guilty, 50% either guilty or hung on the OUI, which is as close to a guilty verdict as anything has been on any vote has been from Karen Reed in the two trials combined that we have done in this case, which I found pretty interesting.
And you also asked the question about what it means. It's a victory. It's a home run. Second degree murder to DUI is a home run. So I don't know. That's the only way that I can view it. I would view it as a great victory if I was a defense lawyer.
We've had trials. We've gone to trial, got somebody convicted of a lesser included. They go to prison for 15 years, and it's a huge win because of what they were actually looking at, what the offers were by the prosecutors in the case. If it was a federal case and they're looking at their life is over forever and they're 40 and 15 years, they're out at 55. Like, that's life, right? You get some life.
And we've even we've gone to trial where we've offered, look, he'll go ahead and plead to this if you drop the racketeering charge. It's a federal case that comes to mind. That you drop the racketeering charge, he'll plead guilty to the tax violations. No, we're going to trial. Go to trial. The jury found him not guilty on the racketeering and guilty on the ones you would have pled guilty to anyway. And that's happened multiple times.
Right. And that's sometimes the job of a defense lawyer, right? Like your client maybe did something wrong, but that doesn't mean they're always charged with what they admit or say they did wrong or think that the government can prove they did wrong. So that's really important. Okay. So question number 2, are her video clips evidence and how should we weigh them? There was the only really argument between the lawyers was that they should say you should weigh it just like any other evidence and give it the weight you deem appropriate, if any, which Jackson wanted the judge to put in. She seemed okay with it. Brennan argued against it. She ended up not saying if any, but just whatever weight you deem appropriate.
It doesn't bother me that she didn't say if any, because I do understand the argument that emphasizes that particular bit of evidence over other evidence. And we know that the jury instruction is all evidence is to be weighted, and that they to treat all evidence the same. Some is not better than others. So they're to look at that as they would look at any other piece of evidence and weigh it the same way they'd weigh any other piece of evidence. It doesn't bother me that she changed her mind on that.
And Michelle said, Peter, the defense actually did argue the extrapolation. I understand what you're saying, Michelle. What I'm saying from my perspective, as a defense lawyer, we've done a lot of DUI trials. Usually it's like days on extrapolation. You have your own expert picking apart, doing your own extrapolation, showing how theirs is wrong, what they did wrong. I mean, it is usually an extreme battle when it comes to an extrapolation like this, especially blood, so much later, and all the different variations it could have been and what could have affected all that. It wasn't a normal battle. I'm very confident that the lawyers would have battled that very different if this was just a DUI trial. Dad, would you agree or disagree?
Oh, I agree with that. Absolutely.
Yeah, it
would have
wasn't
focused
quite
on
as
there's no focus.
right. Okay, now for the big one. What did you think about if we convict on OUI, a lesser included, do we convict on everything for count 2?
Well, a couple things. One is the way she did the jury instruction is the way the Massachusetts law says you should do the jury instruction.
Mm-hmm.
So she was following the conservative route and not changing a standard jury instruction practice in Massachusetts. So that's number one. Number two, it should have been obvious to her that this is not the regular case and just not the standard case. And she should have done something different, special, but I think she was scared to do something different. And it's come back to be proven that she should have done something a little bit different in order to make it a little clearer. But again, most any judge would have done what she did. It's the exceptional judge that would have said, you know what, I don't care what the standard is. I'm going to do what makes sense in this case.
Yeah, I think that's probably the best explanation I've heard for it, because there's nothing legally wrong with it. It's already been upheld. It's how they do it. It's not that abnormal. We've had similar situations with similar, lesser included. You can always ask for it to be better. Like I said, it was the right answer. It wasn't the best answer. I thought she should have gone for the best answer potentially in this case. She didn't. But then what did you think of the edits that she made and the new additions that she put, which was like, once you find not guilty on this lesser included of involuntary manslaughter, then you move down to the lesser included of motor vehicle homicide, et cetera, adding that verbiage in. What did you think of that?
Well, of course, it's the correct statement of the law. That's what the law says. She definitely made it better and more understandable and made it clearer. So she did try to make it a little bit better. My guess is, unless the jury really, really has some lightweights on it, they're going to figure out exactly what you said.
Yeah. Okay. They're here, or people are saying they're back. Let's take a listen to what they have to say here. We don't know what this is, so we'll see.
All right. So I'll see you at sidebar so we don't do this part in open court.
I'll see you at sidebar so we don't do this part in open court, whatever that reason is. Can we do
the
this?
jury's not there. I don't know why she would do a sidebar. Why we have to be secretive about this?
I don't know. That's it. I can't get a better view than this. All right. So were you done with that? I don't know if I interrupted you.
Yes,
Were you
I was. Yeah,
okay.
I was.
All right. Let's get to some questions here. And when they come back, okay, here they are. They're coming back from sidebar. Just kidding.
Jim, can I have that question, please? Thank you.
Well, it looks like there might be another jury question.
All right. So as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got someone.
This is so crazy. It's almost like they literally watched everybody talk about the case. This was the question the last jury did not ask. But once again, those 2 charges should not have even ever been here. The last jury did the same thing. That's crazy.
Put from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions, I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
I don't think that's right.
Certainly not for it. I agree. We can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you
So what he's saying is this question actually came in before, because there was kind of a long period of time while they were all arguing, what are we going to do with these 3 questions? So this question of if we just hang on count 2 and we're not guilty on 1 and 3, is it hung on all counts? Came in before they answered the other 3 questions. And Jackson's like, well, now that you have this new verdict slip, should we say like, hey, give you some time. If that answered your questions and gives you clarity, then maybe you're going to be able to come to a verdict. That's interesting, isn't it?
I think she should give them some instruction. I really do, that so they know that that each case is individual and they're to make a decision on each count.
But
That's
why
it.
would we want to be clear? Why would we want to be clear and make this easy? In what world is it not just say, yeah, if you're not guilty on one, sign it, you can turn that one in if you want. Like, and then you guys can keep it and we give them the Allen charge on count 2. Like, I don't understand. It's not, if it's not guilty, it's not guilty. Like, the Constitution protects people from double jeopardy. This would be triple jeopardy potentially. Like, that's mind-boggling to me. Mind-boggling.
Right. Yeah. And if it is just count, and again, they don't have to tell her which counts.
Right.
But that they can sign verdict forms on individual counts if they've reached a verdict. On the one they haven't reached a verdict, on that one, I'm giving you the Allen charge.
Right.
You know, she just leaving them in limbo with a question like that, I just don't think just or fair.
And
If I was on a jury, I'd be really bothered by that.
I agree. But the issue is, so number one, I've heard in Massachusetts, if you're hung on a lesser included of count 2, they can try you for all of count 2. So they can come back later on manslaughter and try them again, which really sucks. Imagine if the defense, like, it looked like a genius move, but if they're hung on the OUI charge and they would have gone not guilty on everything else because of no collision, that's got to keep you up at night. I wouldn't sweat it if I was them, because honestly, like you said from the jump, the jury's usually looking for some kind of compromise. If they weren't going to compromise on this, maybe they were going to compromise on anything. So they shouldn't lose sleep over it. They made a decision that I think was potentially a very good decision, and they've got to just kind of live with that. As lawyers, we make a million decisions throughout trial. We can't, go crazy over each individual decision, but pretty wild to me. Let's hear what else she says.
proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those two counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature.
No, there is also that case in Massachusetts that was cited where they agreed on guilty on counts 1 and 3, but they went and kept deliberating and they never came to a final decision. So the court's probably thinking about that case too. They may agree now, but it's theoretical until it's final. And that case law is out there as well.
Mature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and
Shock.
we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say.
Good point. It's not a question for later. If you tell them you cannot answer it, they're not going to ask it again, right? Because she's making it seem like, well, maybe if they
Right.
ask later, then we'll give them a different answer.
Maybe she should go. Maybe she should say something like, "If you have reached a unanimous verdict on any of the counts, please let me know, and I'll instruct you how to conduct yourselves at that point."
Yeah, I mean, he should date and sign the bottom, right? I mean, then it's over and turn it in.
Yeah. Right.
I can't answer the question because the court can answer that question. The court absolutely can answer it. I would simply say this question is not before the court without further information or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever
do you say?
those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, John?
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute.
I mean, that's so annoying that she wouldn't give them 2 minutes. Like, what kind of joke is that? 2 minutes for criminal defense attorney team to confer with counsel, and she's like, you can have 1 minute. What world are we living in? Like, I don't know. Could you imagine that, Dad? Like, asking for 2 minutes and the judge saying, no, you can only have one? Like, that's crazy.
Well, it's like asking for, was it an hour and 45 minutes for closing?
Hour and a
or
half,
something?
an hour and 15. Yeah.
She always has to. What it is, it's a power thing. She's got to show she's in control. So even if it means that she cuts them 1 minute, it shows, look, I'm the boss, and you're not going to tell me what to do. That's her theory. I mean, that's the way she operates.
Crazy. And she says, you know, she's being coy, and she's saying in front of the cameras, we have steps to be able to fix that in the future. But what are those steps, and why would we not start taking them now? Like, it's so clear. If you take all 4 questions in context, they're not guilty on 1 and 3, and they're hung right now or arguing about OUI. I mean, that's what everything is pointing to. We don't know that to be a fact. We don't know that to be true, but that's what everything is pointing to. So why take the tools out of their hands to give a verdict? I don't understand that.
I don't either. I don't.
All right. I'm going to skip ahead here while they confer.
Just now, in court, I don't
All right.
have a principle.
Now we get to hear after they conferred. What are they arguing?
Just with a very slight tweak of the court's language, I don't have a principal objection to the court's language that if we not answer the question this time, I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan?
Yeah, he wishes she would say that it's premature to answer that, meaning ask it again later, which is pretty much what the judge said, but she's not going to do that.
My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with the first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer.
Yeah, I was thinking, like, what does she mean consequences? Like, a guilty or not guilty verdict is the consequence of the question they're asking. Of course, they're concerned with whether they're going to vote guilty or not guilty. She's talking punishment.
A question like that. This is not the consequences of the verdict. It's how do they report a verdict.
Peter, I'm going to have to cut out. I will be back.
I can't answer.
All right, you're leaving right now?
I'm going to leave. I'll be back, and I'll be back.
Okay.
Okay.
I'll save as many questions that are addressed to you as possible.
Okay.
Text me when you can come back. It's the same link. All right. Let's continue listening to this argument here.
Answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns and it protects Ms. Reed's rights. I think that.
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
Yes, Jen. Very good sign, in my opinion.
Probably quick to finish writing, but at this point, that is over our objection. I don't.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question. It could be answered.
Yes. Do you notice the difference in the battle here with these juror questions and what she's going to say to them and when? Very different than trial one. A lot more forceful out of the defense, and I think appropriate. Laying the record, not saying, oh, we didn't have the opportunity to object. We didn't have the opportunity to set the record straight. No, no, no. They're taking the opportunity. They're forcing the opportunity as they should.
In an innocuous way that does not affect Ms. Reed's rights.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So,
I didn't
Is
say
that-
to ignore anything, Your Honor.
all right, we are all set. So let's send this in.
So it sounds like maybe Yannetti at sidebar said to ignore it. And what I will also say is ignoring it is also different than what Judge Cannoni's doing. Ignoring it is not saying I'm not going to answer it or I can't answer it. So ignoring it is still better than what she's doing for the defense, in my opinion.
All right.
All right, so I think she's going to get the jury. Or maybe she's just sending that written answer back. So it wouldn't be abnormal for her just to send that written answer back. All right, I still have it up in the background, and you guys can let me know if they are back in court. I am going to answer some questions. I will save a bunch of the ones for my dad for when he gets back. We're going to probably extend the stream a little bit today because I think there's a chance we get a verdict or maybe some more indication that this might be a hung jury. If she's found guilty of just OUI, will she be handcuffed and taken to jail right after court ends, or can she go home? It depends on how they do it there. I don't know. I've had cases where clients are hauled into jail that same day. Sometimes on very serious charges, worse than DUI, they're given some time to handle their affairs before they surrender themselves. So it really depends. I think she'll be able to go home before sentencing, I would hope, because it's not automatic jail. So, but I don't know how they do it there. Peter, did you know Leslie's 67? He looks and sounds great. Hopefully we'll have a verdict today. I did not know that, but that's good. He does a lot to keep him young. Grayson, do you know the story with those doc interviews? Did she not have counsel when she made them? Why did she do them if she could be clipped and used? I would have to say that she did have counsel at the time, and they knew this was a possibility, and they thought it was worth the risk. Pita, can they find her guilty on second degree and then OUI, or do those questions seem like a not guilty on second? So, second degree. Oh, yeah, it would be probably included because it is second degree with a, let me see, second degree. So I guess they could find her guilty of second degree and the OUI, it looks like from this. Yeah, because they're each individual charges. OUI, the second degree does not mention the operating a vehicle under the influence. A couple of the second count, sorry, I was getting second degree mixed up with second count. Second count would be included so that she couldn't be convicted of vehicular manslaughter with OUI and OUI. If the jury was seemingly leaning guilty for OUI only, don't you think Bev's answer instruction to the question might make them lean not guilty on OUI now? Possibly, but it could just mean they're hung on OUI. Right? It could just mean they're absolutely hung on OUI. Shout out to the gal from Mass I met last week in Kauai. Great to talk Karen Reed on vacation in Hawaii. Hope you took my advice and are watching Lawyer You Know. Wouldn't that be hilarious, Christine? Could the videos of the doc series question just for the driving drunk thing? Absolutely. I think it makes sense in context what they're considering and kind of how they're working down the deliberating path. Lane, hi Peter. I'm a contracting officer that has obligated millions for X contracts. I really enjoyed your coverage of the experts in this case. Civilians have no idea how high the costs for experts are. Yes, sometimes I'm shocked, and I've been doing it for quite a while. And Dan, why does the verdict slip have to be so complicated? Why can't we have not guilty / guilty check for each charge? Even her additional verbiage, right? Even her additional verbiage, I think, is better, but it's not perfect. It's not the best answer. If they find her guilty on OUI, would she be taken to jail? Again, possible, but unlikely. I think that's very, very unlikely. AJ Hot Mike, I can't do this again. Bob, thanks, lawyer, you know. Oof, that's pretty wild. That's pretty wild. She would need him if she has to do it again. Thanks for your amazing coverage in this, Peter. I've been following you since the first trial, and I've learned so much about the law. I feel a not guilty is coming. And so when people were saying, where you feel like 60% not guilty, I felt so confident on counts 1 and 3 not guilty. I just don't know where they're going to land. And I know most jurors like to split the baby. And adding the OUI really bumps up the guilty chances. If you just look at our chat again today, 52%-ish say not guilty, 48% say guilty or hung jury, and it's a higher percentage of guilty voters than when we voted on it yesterday, even this chat. And I trust this chat, and this chat's a very high percentage of not guilty on second degree, but split decision on OUI basically, which tells me it could literally go either way. I don't consider the chat wrong when you're 50-50 on something, right? I consider that we don't know. What if they hang on OUI only? Then it seems like they can retry her for everything in count 2, including manslaughter. What happens if they all agree not guilty on main charge 2, but can't agree on DUI? I don't get it. They would hang on the second charge. They would hang on the second indictment. So yeah, people are saying, up to 2.5 years potentially for OUI. That's like the worst of the worst kinds with, additional aggravators, not a first time OUI like this that did not result in death because the jury did not find that. They had every opportunity to, and they in fact found that they did not prove that. What's up, O'Rourke? Peter, last night you said you've never been drunk. You always went to FSU. How are those reconciled? Thanks, LOL. I'm an enigma. People say I'm an enigma. Grayson, why would her lawyers or the court allow clip videos without requiring the jury to watch the entire doc? This seems incredibly wrong and illogical. People clip things out of context all the time. So I don't think they would have been able to put in the entire documentary, but they chose not to play clips that would add context. And that's the issue. And that was their decision. I will just tell you, this was a law school class in legal strategy from both sides. Brennan took some swings. He left some stuff out. He focused on some stuff. Jackson, Yannetti, the whole defense team, Alessi, everybody involved, Little, everybody involved, they also took some swings and pulled some punches. Very different trial 2 versus trial 1. Yes, OUI is operating under the influence. It's like a DUI or DWI. Different jurisdictions call it different things. Curious if you both think, okay, I'll save that one for my dad. At the time, you disagreed with calling Devers and not Proctor, but came around eventually. For the life of me, I can't figure out why they let her do these interviews. Jackson was a part of one. Yeah. So that's something that I have not come around on. I have not come around thinking, oh, wow, it was such a great idea for her to do those interviews. And I don't think I'm going to. This just kind of, reinforces that. If not guilty, do you think the Commonwealth will attempt to try Higgins or Albert? I really don't. I think no way they will admit they attempted to convict the wrong person. I agree. I think there's no way they do that. I also think that if I'm representing Albert or Higgins, I'm pointing the finger at Karen Reed. Last one with him, driving with him, calling these angry text messages. Look at these videos she made. You're pointing the finger at Karen Reed for not guilty all day with the Alberts or the Higgins. And you don't have to even talk about the collision and all the stuff that was horrible evidence for the Commonwealth. Usually all the cops, look, Proctor thought it was Karen Reed. Gallagher thought it was Karen Reed. You say all the cops investigating the case thought it was Karen Reed if you're defending Albert or Higgins. It's just so hard to go back and win a trial after they have put this much resource and time into convicting somebody. Now you're going to say it was somebody else. That can all be used against you as the Commonwealth. Curious if you both think a verdict today is more probable than not. Sorry, I keep pulling that one up. If they find her guilty on OUI only, will the judge sentence her today? I don't think so. If not, they're not going to say much after the verdict, which would stink. Yeah, but I think they're still going to say they're happy with that. I still think there's no way they're not going to be happy with that. Can they something her not guilty of 1 and 2 and be hung on OUI, or will the whole thing be mistrialed? So they absolutely should have the opportunity to acquit her on counts 1 and 3. And I hope that they don't think they can after this instruction from the judge. And the worst case scenario is they just say they're hung on everything. And later they come out and say, oh, we thought we couldn't do that because of the judge's answer. Then we have a mess for appeal. When in reality, we really should not want this for a criminal defendant. if the jury truthfully came back. This is what I was saying the first time around when we were getting those reports. The questions to make it sound like the jury is wondering if they should base OUI on her clips saying she shouldn't have been driving. Is the evidence, exhibits, etc., organized for the jurors when they go back, or is it like stacks of banker's boxes and good luck, hi, Papa T and Peter? So yeah, usually they get binders with tabs, and they get, the plexiglass and stuff like that. So it is pretty well organized for them, with exhibit numbers, what they came in as, and they can flip right to it if they want to see it. DUI laws in Massachusetts are very tough to beat. If there are lots of questions from the jury, does that reflect back on the judge? Bad, unclear jury instructions? Not necessarily. I like it. It means you've got a jury that's paying attention. They want to do this right. They've got a lot of questions for her. I like to. I mean, I can't tell you how much more I feel like I know what this jury is thinking now than before they ever asked a question where you really know nothing. If I'm the defense, here's what I'm saying. This can come back to bite you as well, but I would be supremely confident. I would be supremely confident it's OUI or nothing right now. And I'm hoping they come back with OUI and not hung on count 2. I would much rather them come back with an OUI conviction than hung on count 2, because then the Commonwealth could do it all over again. And it leaves a lot of the open questions. If they're just guilty on OUI, I can say, oh, no collision. Karen Reed did not hit John O'Keefe. She may have been driving drunk. A lot of people were driving drunk. Not a ton of difference. I mean, every statute and every jurisdiction can have a little bit of difference, but generally the same thing. Not knowing every state's jury instructions, imagine how many guilty charges there are based on confusion with jury instructions. Isn't it best to vote not guilty based on juror confusion? I mean, to a moral certainty. So if you're confused and you don't think the Commonwealth proved what these instructions are saying, yes, you should vote not guilty. If you feel like regardless of the instructions, the Commonwealth proved beyond a reasonable doubt and in Massachusetts to a moral certainty that the defendant committed a crime, then you should vote guilty. Oh, I'll save that. Or that's not a question. Hi, Pizza and Papa Tragos. This feels an eerily similar to last trial. Love you guys. I have my mom watching every live and Sunday podcast. Yeah, I was shocked when they read that second question. Shocked. We are living in biased Bev's world. They look on her face tells me she's not remotely interested in justice. It's very disturbing. And if I was the jurors, I'd be pissed. So one thing I thought was kind of interesting is I wanted to see what her tone was like when she was reading through count 2 again. And I think it was pretty neutral, if anything negative, if I was a juror. Like, she's not really happy with this. Do you think the defense regrets adding OUI? I don't know, Ashley, because there's two ways to look at this. Were they kind of quick to say no on everything else, knowing they could dig in on OUI? Are some of the not guilty, no collision people using the OUI as like a negotiating chip? Like, well, maybe we'll just convict her on OUI. Because if that's the case and they kind of forgot everything and are focusing on OUI, maybe it's a win for the defense, right? I don't think they should second guess it. I think they could. I think there's going to be people out there saying, I told you so, you shouldn't have done it. It was absolutely a risk, but I think it was a risk worth taking for the defense. I would hate if they hung on it. And, it does basically come back to bite them as being a bad decision. But listen, they've made a lot of tough decisions in this case, lawyers on both sides. So I don't think they should really sweat one as the end all be all. Do you think the jury would just be over Bev's antics and just say not guilty on OWI just to be done with it? So my perspective from talking to jurors, they usually like the judges. And if they don't like them, they're kind of indifferent on them. Like, I wouldn't want to be friends with the judge. Very rarely does a jury hate a judge or think I'm over this judge's antics. I would be surprised. Aren't they using if because instructions told them not to give the verdict beforehand? Again, we'd have to be in their head to know that. To me, it seems pretty clear. And again, she did say it's theoretical. So if they're like, okay, it's no longer theoretical, we have voted not guilty on these two. Anyone else terrified Bev will make her serve time, even if she's just OUI? It is it's something to worry about. I think it would be wrong, but how does the defense know she will write it as asked she has priors? That becomes part of the record. Her answer becomes part of the record. Can they appeal the OUI? Yes, they can appeal the OUI. Peter, is there a law in Mass that it's all counts decided or else a hung jury? If not, she should be able to be held accountable for refusing to add the guilty, not guilty to each count. Karen Reed's life's at stake. So she did add guilty, not guilty for each count. And they can vote not guilty on the 2 counts, but it's just within that lesser included. That is the way Massachusetts is talking about it. All could have been avoided with a better form. You would think so. I don't think they would have had this question if the form was different. That's my opinion. If I was the juror thinking guilty on lesser OUI and wanted to know if I could convict on that and not everything else attached, and I got that response from the judge, I would switch to not guilty because of it. I mean, here's the point. And Speeves, I appreciate this comment because every juror could be thinking something different back there. Every juror could be thinking, well, now we got this answer, I'm going to do that. Well, we got that answer, I'm going to do this. Ashley, can they ask to remove the OUI charge? Not at this point. Not at this point. The Commonwealth could drop it, sure. They could drop it and the defense could say, sure, we can take it out, but it's not going to happen, I don't think. I would be a petty juror, and if she can't answer, I'd just do not guilty on all counts. But if you're being petty, how do you know the judge wants you to vote guilty? What if you're petty and you vote not guilty because you think that's what the judge doesn't want you to do? The compromise shouldn't be made at Karen Reed's expense. Seriously, they need a whole open investigation for the McCabe's and Alberts, in my opinion. If they can't determine the time of the DUI, that's reasonable doubt. No. I mean, if the Commonwealth didn't prove when she was driving drunk, yeah, that's a pretty big problem. Been following since before trial one and so ready for Karen Reed to be free, but gutted for OJO. Will likely never see justice. Love from London. Yeah, I will tell you what an OUI conviction doesn't do. It does not provide justice for John O'Keefe and his family, in my opinion. Isn't the judge just lying to the jury? I can't answer. Well, theoretically, she can't answer it in the form that it's written at this time. So, well, I guess she could try to answer it, and she is answering it, right? I sat on a jury in Massachusetts for a simple case, and the verdict form and jury instructions were convoluted and confusing. I think that's a common theme throughout jurors, that it can be very, very confusing, which I hate. Peter, how can Karen Reed be convicted of DUI when the Commonwealth doesn't know when she had her last drink and was not caught or witnessed driving under the influence with the evidence they presented? Is it enough? We'll see what the jury says. Again, I'm repeating myself when I say if this was just a DUI trial, I think the defense would have had so many arguments to make, some of which you've pointed out here. But based on the simplicity of how it came forward, I could see how a jury could vote guilty on the OUI charge. The hot mic moment is, Bob, I can't do this. As if ask him to wait while he was busy with something else. I slowed it down again. Okay. They didn't say again. Can't they legally give separate verdicts? If yes, then isn't this a fraud by not telling them? Just sounds so wrong to me. Is a hypothetical question that's different than saying, here are our verdicts and her throwing them back. Why can't Bev instruct the jury to consider each charge separately? This is the farthest thing from theoretical, especially since this problem happened last trial. Yeah, well, again, they're not supposed to necessarily take into account last trial versus this, but shout out to my 2.5 son, little Willie Cook, who loves watching Peter. What's up, little Willie Cook? Judge can give the Allen charge still if she has to. Yes. Glad I found your channel. Karen Reed is not guilty. Can't wait for the Adelson trial. Go Knowles. So I talked to some people involved in that, and they said they think there's a real chance that she gets her venue changed. I said I would be surprised because then it would almost feel like, well, did everybody else tried in that jurisdiction get a fair trial? Interesting. I'm sending you chats you seem to miss. Thanks. Think I'm getting all of as many as I can. There's still a lot up here. If hung on OUI, will they retry the case? So it seems like they'll be able to retry the entirety of count 2, which my guess is they might. I'm still confused why Bev is saying she can't answer this. How does her answer change depending on when they ask? If they say, we have come to a verdict on count 1 and 3, can we be done with those? And it's more assertive, like they are done. It's a final decision. I'm trying to get into her mind, right? I'm guessing there. My son every day lately, Mom, what did Peter say today? Love you, Wyatt. And hi, Mom, Ginger, or Ginger, as we say. Experts aren't cheap. Maybe they got paid for the interviews. Potentially, like it went to the defense fund or something. I'm just continuing to keep an eye on court. I assume you guys will let me know if they come back. Could the jury write not guilty themselves next to each charge if they find not guilty, even though it's not there to check? I mean, they could, but in reality, they're really only going down to the next one if they all agree on not guilty. If I was a juror and I want to be clear, maybe I would just circle the not guilty in the actual instruction. The judge should ask the jury is this hypothetical or are you hung? Instead of assuming their question is hypothetical, well, they're not telling her, hey, we're hung here on count 2. They're saying, if we hang on count 2 and come to a conclusion on the other 2, which is by definition a hypothetical. I'm working, but don't want to miss the verdict. I get it. I get it. How many people agree with Mags in the chat? C. Logan. So why weren't the verdicts that they reached in the first trial not upheld? It seems we're right back where we started. Love your show. Love you. So they weren't official verdicts. They weren't signed on the verdict form. They weren't turned over. They weren't entered in open court. Seems like this jury wants the opportunity to do that. The prior jury never asked the question quite so point blank like this jury just did. Why the TV deal? Apparently it was filmed during the first trial. They never thought it would make it to court. She got paid and needed the money to help pay for her defense. This was the rumor, at least, which makes sense. It sucks, though. Hindsight doesn't, it's not great. If this trial ends like, it's almost like OJ, what if I did do it or whatever? Ends like the last trial, can the defense do anything to prevent 3? Any appeals? Probably the same things they did to try to prevent trial 2. Glad you're here with us for this madness. It is horrible. Form was confusing. Could they have found her guilty on count 2 and didn't realize they were supposed to stop and just kept going, just nervous? A lot of things are possible. Can the jury write not guilty on lesser included and specify hung on OUI? They can try to, but seems like the way the law is written, they would still be able to retry her on the entirety of count 2. If they're hang on OUI, would she be guilty on the entire second? No, definitely not guilty if they hang on OUI. Did you say this question came before the others? Yes, that's what the judge said. That it came before she gave, not before the other questions came in, before she gave the answers to the first 3 questions, because we know there was kind of a time block there. During closing, could Alan Jackson have said something to the effect of, when viewing the Karen Reed clip, ask yourself why the Commonwealth didn't let you hear the questions and answering just to put doubt on the clips? Absolutely. And he could have said, you hear they're clipped in the middle of a word. These clips were taken out of context. That would have been a reasonable argument to make based on the evidence. Does Mass allow, he couldn't say, well, she said X, Y, and Z earlier in the video. He couldn't have said that. Allow for polling of the jury on each count to avoid last year's debacle. Love you and Papa T. Yes, I believe it does. Sounds like they believed ARCA this time at least. Yeah, which, I mean, that seems commonsensical, so that makes me feel pretty good. Would it end if Karen Reed pled guilty to OUI? I do not think so at this point. We'll see if that comes in the future. And everybody was calling me crazy before. I said, I think they should have presented that to the Commonwealth, like, hey, we'll plead guilty to DUI. And it seems like they may have done that, based on the fact of their feeling of getting this OUI charge listed as a lesser included. Feels like we're back at square one here. And for the record, I say in here, PETA in Lois's voice from Family Guy, and that's the only correct answer. Can you remind us what the defense chose to include as the lesser included? So the lesser includeds are, so the first one is manslaughter while operating a motor vehicle under the influence of liquor, involuntary manslaughter, motor vehicle homicide, and operating under the influence of liquor. Your dad was right. This judge is about power. The form was confusing. Could they have found her guilty on count 2? It included the alcohol question on and didn't realize they shouldn't have stopped. I'm still worried. I'm not sure exactly what you're asking, but I mean, there's a bunch of different ways they could be confused. So rest assured, if they fill out the verdict slip wrong, meaning they click not guilty and guilty of a lesser included, they will send it back and be like, hey, you did this wrong. Maybe with more instruction, maybe not. If you remember the Johnny Depp case, they filled it out wrong. I'm confused. Are they hung on OUI or manslaughter? We don't know. We don't know. It sounds like it's something on count 2, maybe a lesser included. They referenced number 5. And I don't think they're doing that to be coy. I think they're doing that to be like, hey, let's give them an indication. Maybe they can help us out if the more information they have. Also, if they fill out the verdict slip wrong, most jurisdictions allow the lawyers to look at the verdict slip and the way that it is filled out wrong. Is defense strategy to be hands-off on DUI time helpful to their case that it wasn't a vehicular death? So it's definitely huge in the fact that they're trying to prove this was not a death by motor vehicle. Peter, I'm confused. Which charge are they hung up on? So we don't know that for a fact. It sounds like, based on reading all 4 questions in conjunction, that they may be not guilty on counts 1 and 3, and they're all the way down to OUI and trying to determine if she's guilty or not on that, and want to know what happens if they can't agree on that lesser included. Would you move to set aside an OUI guilty verdict? No, it's not going to happen. I mean, would you move to do it? I don't see a reason for it. I mean, they'll probably file a motion afterwards, like you always do to protect the record. If Karen Reed is found not guilty, will she get her Lexus back? What happens to the car if found guilty? I don't know the answer to this. I would assume, obviously not guilty. I guess she would get it back. I forgot that it was even still in the possession of the Commonwealth, but I guess it's evidence. I don't know how destroyed or picked apart it's been. That's a good question. Why did the judge say, I don't want to make this complicated for you, or something like that to Alan Jackson, then said to Yannetti, this is what I'm inclined to do? Because I think Jackson and Yannetti may have disagreed up at sidebar, or Yannetti may have said, ignore this. And now Jackson's saying something different, and she doesn't want to make it seem like there's trouble in paradise. The jury could just say it's not theoretical. That's true. I think something the jury has probably learned now that they didn't know 2 hours ago is we could get real questions to answers. Let's ask. If we ask something stupid, they're just not going to answer it. If we ask something real, we might get a new verdict slip. Peter, if I were a juror on this, I would have to vote not guilty because of the lack of clarity. I think there's a chance. Do you think if this was a civil case that the evidence would have been enough for a wrongful death conviction? No. I still just don't think that they have proven by any burden, much less beyond a reasonable doubt, that he was hit by a car. It's such semantics. Words are important, yes, but she is digging in on when Alan Jackson is right. She can't answer it yet. P.S. My 5-month-old baby girl loves watching Always Smiling Huge. So that's been kind of a common theme, is like younger babies. They're like, they just know your voice. I did it so much while I was pregnant and just listened to your voice. And now they came out and they just look whenever they hear your voice. It's like, I'm just the voice that's stuck in that box that is the TV or the computer screen or the phone screen. How can they do guilty OUI when there is no chain of custody based on her not being pulled in and getting her BAC immediately? There is too much reasonable doubt on when she was drinking. It's guessing. As a juror, I would be hard-pressed to convict her on OUI while knowing that Higgins and everyone else in the group was OUI that night. It would feel like selective enforcement and fundamentally unjust. So number one, theoretically speaking, you wouldn't know that none of them got arrested for DUI, right? I guess theoretically they could be too. But I get what you're saying, and some jurors may feel that way. That's not how it works, because individually there could be co-conspirators that are not part of this trial. There could be other guilty parties. You're supposed to just be focusing, did they prove this person committed a crime? The hot mic caught Alan Jackson telling Alessi, I can't do this again, Bob. During deliberation, everyone's getting worn down except the Commonwealth. Bev, don't tell me anything until you're decided on everything. Also, Bev, I can't answer hypotheticals. It's definitely an issue. Brian Ferrara. I know a Brian Ferrara. I'm trying to look at this picture to see if it's the Brian Ferrara that I know. Thank you for gifting 5 memberships. Couldn't she appeal the OUI and get a trials? She can definitely appeal it. I don't know what you mean. I don't know what you mean specifically there. Possible a juror does know what happened in the first trial and is trying to stop whatever happened before. I guess I would think that would have been fleshed out potentially in jury selection. But I don't know. I'm at work risking getting in trouble, so I can't watch with you. What are your thoughts on making jury rulings, majority rulings? Not saying it's a thing, but just wondering. I would hate it. Big, important issues go before a jury. Only ones that we can't answer. And if we start doing majority, you can do a bench trial if you want to. I just would not want a majority rule for the jury. I really wouldn't. Okay, I'm late, so I apologize, but is the situation that they agree on 2 or 3 charges but hung on 1? So it must be most likely will be not guilty, charge 1 and 3, and guilty on 2 OUI. That's what people are guessing. We don't know that to be a fact. There's def evidence of OUI. Some not guilty jurors are probably digging in their heels, thinking in back of their minds a conviction means a win for Proctor. If they did, that's a great job by Alan Jackson and the defense team, because that's exactly what you want them to think. This is our team. That's their team. Proctor's on their team. Would being hung on OUI hang all of count 2? Yes, it seems that way. What's count 2, number 5, OUI? So 1 is not guilty. 2 is guilty of the offense charge, which is manslaughter. 3 is involuntary manslaughter. 4 is motor vehicle homicide. 5 is OUI. Have faith. Have faith. This jury ain't gonna be fooled. They definitely seem like they've got their finger on the pulse. Maybe they're hung on OUI because the jury to decide weight of clips. One or more don't agree that the clips support OUI. No chemical test result. There's definitely issues with the OUI charge. So I can see a number of different things the jury might be looking at, like this is not good. This is not good to prove a DUI or OUI. Is this a good or bad sign for Karen? Depends on what you think of the OUI. I think these are overwhelmingly good signs for Karen Reed. That's the way I view these jury questions. Thank you, Nora, for the super chat. If they are hung on OUI, is it still not guilty on all the other second-degree counts, i.e., can they try her again for DUI? Again, I'm qualifying this in Massachusetts. It seems like the answer is they can retry her on all of count 2. Manslaughter, involuntary manslaughter, all the lesser included. If the jurors agree on not guilty to the higher charges, but got hung on OUI, how would they communicate that on the form? They could sign and date counts 1 and 3, turn them in, and tell the judge we are hung on count 2. They could say OUI or just say count 2, but official verdict, give it to the court. That's what they should do. Thank you, Kitchen, for the super chat. Yeah, the interesting part about the OUI too is there's no even evidence of like dangerous driving. I guess if you think she hit somebody, which this jury doesn't think she did, where is the evidence of dangerous driving? Like weaving in and out of your lane, running a stop sign, running a red light, speeding, driving with your lights off. You know, all the things you get pulled over for that you hear in normal DUI cases, which just is anything but. Hi, will there be any consequences for Brennan for his conduct during trial? Unlikely. Burgess CV and report not knowing. Hoodie, if so, how and what? Highly unlikely. He could get some public reprimand if the bar, Massachusetts State Bar, says, you know, this was unethical conduct or prosecutorial misconduct. I hate the idea of just settling on a lesser included. I think she should be not guilty on everything, but I think it is still a win just for OUI. I get it, but you have to realize the jurors sitting back there, they're different. They're not the same as everybody that's been following this case forever. They're just not. Grayson, do you happen to know the original story behind the now clip documentary interviews? Why did she do them? Did she ignore counsel? This seems like such a significant avoidable mistake. So people are saying that maybe they got paid for the interviews. Maybe it helped pay for the defense. They were filming this during trial 1. They thought they were going to win and they didn't. So then it all becomes admissible. Are the other charges both OUI indicating she hurt John while driving drunk, or is just OUI, which is kind of true? So the just OUI, you can convict on that without a collision. Anything else, you'd have to say a collision happened with John O'Keefe or she caused John O'Keefe to die with the motor vehicle. Peter, is reasonable doubt if you're not sure, or that then you have to acquit so they're not sure about anything about this charge, so they have to acquit, right? If you're not sure, that is reasonable doubt. That should be a not guilty verdict. Thank you, C. Mercy. What if the jury comes out and asks, we find her guilty of OUI, but nothing else? The judge would probably say, then fill out the verdict slip to reflect that and sign it and turn it in. I hope the jury says it straight out, like we are hung on lesser included number 5, unanimous on everything else. If we hang on number 5, will charges 1 and 3 and 2, 1 through 4 be dismissed? Can she answer that? So I think she can, if they say it as a dispositive thing, like it is over, we're done, she can probably give them some direction on how to sign off on counts 1 and 3. I think it'd be more delicate on how she would answer what they do with count 2. Kevin Albert admitted to drinking in his police vehicle with Proctor and misplacing his gun badge. He received a week of paid time off. Peter, I'm so frustrated she wouldn't just tell the jury a split verdict is allowed, especially when she knows that tripped up the last jury. Again, we have to be careful. We don't want to give too much information. We don't want to sway the jury one way or the other. Can you read out the charges on each account, please? Yeah, give me a second. And I'll pull that up. Why can't they show them several examples of how a jury verdict sheet could be filled out? The lawyers can do that in closing argument. They absolutely could have gone down the line and explained this in closing argument. What is the difference between OUI and DUI? Nothing really. Maybe already asked, but if they don't know the time frame for the OUI, how can it be proven beyond a reasonable doubt? I think that's a good point. And that might be some of what the jurors are saying. Like, listen, you don't even know the time they're trying to prove. That has to be not guilty. Didn't you listen to the defense attorney in closing? If manslaughter charged guilty, then that states she hit him. No way he was attacked by a dog. Sure, if they come back with a guilty on manslaughter, I would agree. If guilty on OUI and not guilty on all others, can Karen Reed still appeal the guilty conviction? Yes. What would happen with the other not guilty verdicts in that case? They're not guilty. She can't be retried. Isn't it ridiculous to think that each juror looked at social media news coverage every night and weekend? I think you mean they didn't look at it. Why make the simplest the hardest for the jury by introducing a slip very much resembling the slip last time? The jury has a constitutional rights. So the defendant has constitutional rights to not be confusing like that for the verdict form. Hot again, man. I don't know if is it hot in here. Or is it just me? It's because I'm like nonstop talking for an hour and a half. I'm trying to see if my dad is going to come back on to answer any of these questions or if I should burn through them. Does convicting guilty on a subcharge, example, offense 2, number 5, convict on the overall charge, if they hang on OUI, is there still, they are going to be mad if they find out later the Commonwealth can retry on top count? Potentially. If they told the court they were hung only on the idea of simple OUI, do you think it would change the thought for the Commonwealth retrying the case? I don't know. I don't know what it would take to change the Commonwealth's thought on retrying the case. Isn't there a separate charge for OUI separately from count 2? No. Judge seemed much less polite and cheery towards the jurors when explaining the new slip. I would have felt dumb and slightly insulted if it were me. Majority verdicts, 10 out of 12, were allowed in Oregon and Louisiana until 2019, 2020, when SJC ruled that violates Sixth Amendment. Yeah, I hate the idea of that. If you're the defense this time around, are you asking for an Allen charge? Also, could you briefly go over the first 3 jury questions? I missed them. Thanks. I mean, I'd feel pretty confident they're just talking about the OUI, so maybe I would want an Allen charge to really try and get a verdict here with this jury because it seems like they've convinced this jury there's no collision. The 3 questions were basically, what time are you saying the OUI was at, 12:45 or 5 a.m.? Is Karen Reed's clips evidence and what weight should we give them? And now I'm kind of confused with all the questions about count 2, but basically, if we're hung on count 2, does that mean we hang on all the charges? Something like that. Let's say they're hung on the OUI. Do the jurors know that she can be retried on all of count 2? Is that explained to them? No. No, it is not. Peter, let me wear the president. LOL. Thoughts, just for a little quick aside show. The president, which is this watch, was my dad's favorite watch that he had. He always said he would leave me when he died. And it was literally my favorite watch. So when I started buying watches and liking watches, I was like, I got to get me one of them. And that's how it happened. Thoughts, when will the law catch up? Civil case. Yeah, I mean, the law is always a little behind, unfortunately. Hi, Peter. Can Karen Reed plead guilty right now before the jury? No, that's not really how it works. How can OUI be separated since it's an M trial? Just like it is, right? It is a lesser included offense. If you were Karen Reed's attorney or on the jury, how would you feel about her answer to the most recent question? I'd be annoyed. And I'd be like, she's creating the problem we were trying to avoid from last trial. That's how I would honestly feel. Thank you for all your tutorials. Those other law podcasters are just jealous. Ignore the haters. I don't think a lot of the, I mean, maybe it does, and I just don't know it. I don't think a lot of the hate comes from other lawyers. Frankly, a ton of real world lawyers have reached out to me, connected with me on LinkedIn, sent me nice messages from all over the country, which has been amazing. And they're like, I love what you do. Keep doing it. People don't understand. And they're really, your chat really seems to understand it. I'd love to have someone from your chat on my jury. So that, I mean, it's a really cool thing that's happening. And you know, with anything that people are talking about, I mean, it's crazy right now. I don't know if we've ever had, we have 35,000 people watching on Twitter. Like, is that a real thing? Is that a real number? I don't even know. And then another 23,000 on YouTube, which is just crazy to think the amount of people that are watching and paying attention to this. For experts, does money depend on the opinion reached? No, it's almost always based on hourly, on how many hours they put into the case. I used to work for the prison system in Massachusetts. If she had to do time, it would be horrible. So she wouldn't go to prison. It would be county jail most likely. I wonder if she would do home confinement potentially. She does not belong in prison. I remain in the not guilty camp. Also, did she spend any time in jail at all? Because like if Judge Canoni wanted to give her jail time, she could do like, 7 days, time served or whatever. Would love your new take on the juror interview on Turtle Boy. I have not seen it, so I don't have a take on it right now. First time catching up to the live. It feels like everyone is talking in slow motion. It's absolutely astounding to me that Bev is okay with letting the jurors remain confused. How is that a fair trial? See, Logan, can you read the charges out? Sure. Let's do that now. Thank you, Denise. Let me pull these charges up real quick. So this is the verdict slip here. M in the second degree, not guilty or guilty of the offense charged. Count 2, manslaughter while operating a motor vehicle under the influence of liquor. 1, they can either check not guilty of the offense charged or any lesser included offense. And this is different now because they've changed the verbiage, but guilty of the offense charged, manslaughter while operating a motor vehicle under the influence of liquor. Guilty of a lesser included, involuntary manslaughter. Guilty of lesser included, motor vehicle homicide. Guilty of lesser included offense operating under the influence of liquor. Now, after each one of these, they're like, if not guilty here on involuntary manslaughter, then move here. So she's added some more explanation, which I think is important. If you do post-verdict news interviews, please use your positive, genuine call for jurors to speak to help with an understanding of how the judge/everyone did. With the confusion over the OUI, do you still think adding it was smart by the defense? I mean, listen, who's to say that if they weren't putting all their focus on the OUI charge, and I said it was a risk by the defense, right? I said it was a risk by the defense and potentially genius. If they convict on OUI or it's not guilty everywhere, it's genius. But who's to say that if they weren't putting all their focus on the OUI, if you didn't add that all their focus wouldn't be on motor vehicle homicide or involuntary manslaughter or something like that, or maybe count 3. I don't know. Rule this: Sam Burns not getting a drop in a puddle. I hated to see it. I never would want the weather to make the decision in a tournament like that, where it's already tough enough. Peter, so grateful you and Papa T for helping us through this with your educated insight. Keeping me sane today, LOL. By the way, I have the stream up and I am all the way live and still nothing, in case anybody's wondering. The one thing I am not doing while answering your questions is following on Twitter. I'm asking my dad if there's any update because I only have about 15 minutes left max. So we'll see if he comes back. Pursue in the courtroom, FYI per Karen, the 4th question came in before they answered the other 3, not after. Correct. If the jury finds guilty on OUI but not unanimous on any one time, would that be valid since that's technically 2 separate offenses? So that's not a special verdict form or special verdict interrogatory. So that's not going to be something they would necessarily answer. If D can prove Brady violation about x-rays, then can D push for disbarment of Brennan? No, it wouldn't be disbarment, but potentially some kind of sanction or public reprimand. Why isn't the OUI a separate indictment listed on its own form? Because it's a lesser included of one of the charges that they had. Seems crazy to me that make it all the way to count 2 and only hung on OUI would cause a hung jury on the entire count 2. I agree with you, but it makes perfect sense. If they believe that there's no collision and they don't believe she hit him with her car, then I can understand why they're like, we're done with everything else except OUI. Peter, I have been way young from airline all day. My heart is beating out of my chest. Thank you for informing and making us mass peeps so much smarter. So much smarter now. Because second charge is manslaughter while operating a motor vehicle under the influence. If the jury hangs whether OUI, then can't go on to decide manslaughter part, then the whole of second degree charge is hung. I think the answer to this is yes. I'm a little confused at the verbiage of it. Do you think we'll get a verdict today? I think it's really possible. It's really possible. This has kind of been where I thought we'd get a verdict basically this entire time. So a lot of people talking about, thank you, Janet K. A lot of people talking about Sue O'Connell. I also heard her talking about that the defense and Karen Reed were crying when they heard the first 3 questions. I assume it's happy tears, but I don't know. Hi from LAPD headquarters, not an officer, only listening, not guilty. Can't wait. Loving your coverage. I would love to see what some LAPD officers think about this investigation. The theoretical question asked before the 3 addressed with the jury in the room confirmed by Boston Sue. Yeah, and to me, I do think there's a chance that the new and improved verdict slip could help them with what their second question was as well. She could have told the jury, ask it a different way, or I'll allow it. Nurse Kim, hi, Peter. Thank you for your wonderful coverage, both trials, and love when you have my friend, Mr. Betterow, on. Maybe a Nurse Kim lawyer, collab someday. Yeah, Betterow is awesome. And a nurse could have some great insight into this case with the injuries, right? Depending on, what your background is. But I've got a lot of nurses in my family, my mom, all my aunts, grandma, like everybody. And she's helped us with cases, demands, talking about injuries, what treatment they had at ERs, nursing home, pediatric care. That's, ICU stuff. I mean, there's all sorts of great specialties. Peter, if jurors are hung on the OUI, isn't it the easiest for the guilty jurors to say F it, not guilty? I think it's definitely easier for jurors to say, yeah, okay, whatever. Everybody was driving drunk that night. I'm not going to hold this all up just on a DUI. I think that's absolutely possible. And again, I think that could have gone into the thought process of the defense attorneys on, do we want to even add this or not? In my opinion, adding OUI was a great choice. I think it was worth the risk personally. Does the judge read the verdict? Because I figure the jury knows what they want to say regardless of the form. Worst case defense can pull. Yes. I don't know if the jury foreman or the judge reads it. I don't remember what happened last time. You are an example of Philotimo. Thankful for you and what I've learned. Let me look that up. Sometimes I don't want to look it up this because I know phili in Greek is a good thing. It's like what you call your friend or loved one. So I assume it's something like that. It doesn't have a direct English translation, but it generally refers to a complex concept of love and love of honor, pride, and duty, often expressed through acts of kindness, generosity, and respect, particularly towards one's family, community, and country. Thank you, Eleni. Thank you for helping us endure the wait. What's next for us? You guys tell me. I mean, I know Adelson and Koberger seem like they're coming up. You guys tell me what you think is next. Because I know we're going to keep talking about this stuff. Like, I have learned so much through this trial. This trial has been different than any of the other ones. And I'm starting to feel like every trial is just different. And we can learn so much from every trial. I feel like makes me a better lawyer. I'm able to now also talk to rooms full of lawyers. By the way, John's supposed to release a clip of that Florida Association of Criminal Defense Lawyer presentation that I gave at some point this week. So you can kind of see some of the stuff we talked about. And when I was watching it back, some of the footage, my mom just took it on her cell phone. I was like, how many people watch true crime? And somebody screams out, "Free Karen Reed," from one of the lawyers in Florida. It was kind of funny when they did that, but like, people are watching. People are watching. Can the jury ask for the wording of the law on hung jury with lesser included? It's not hypothetical or theoretical, but specific law, case law. No, they're not going to read that to them. Thank you so much for my Emily Show membership. Oh, that's awesome. That's awesome. Yeah, I was in Emily's chat for a second earlier today. She's awesome. And when I was in there, they said John Stamos was in her chat, which was crazy. And she said something about two Greek hair people or something in the chat with me and John Stamos. We're never in the same place at the same time, Uncle Jesse. Welcome, Paula. I've worked on political campaigns and it sucks doing so much work and then hand off the decision to others. Hope the defense knows they did what they could. Yeah. And it's the same thing. It's like you have no idea what people are going to make their decision on. You know what you hope they do and what they maybe should, or what you think they should. Why did they answer the question out of order, or did I hear this wrong? No, I think they asked the first three first, but then just in the time that it took to ask and answer the first three, another question came. So first three questions, then question 4, then answer for 3 questions, then answer for question 4. Nurse Kim plus lawyer, is the perfect collab, please. Lindsay, I've been watching for this case, but now that it's maybe wrapping up, I've gone down the rabbit hole on your channel, knee deep in Lively v. Baldoni. Yeah, there's some other stuff coming out with Lively Baldoni too that I've been waiting for. But we'll talk about that, guys. If you guys have questions about it, we'll talk about it. It's pretty rough. People are pretty brutal on that one too. But hey, I don't know if anything's going to be quite like the Karen Reed experience. Absolutely, Adelson. That case is wild. I would agree. Janine, thanks for the super sticker. Brooke said, let's do Koberger next. Candace, Peter, my boyfriend and I totally appreciate you and your father. We watch and learn so much. #FKR. First must decide if OUI. If not guilty OUI, then manslaughter while OUI. So no, it's the exact opposite of that. You start manslaughter with OUI. Then you go down the road. Now, if you're saying, like, theoretically speaking, in order to ever get to manslaughter while OUI, they need to prove OUI, and the jury could be looking at it backwards, that's possible. That's not how they were instructed to read the verdict slip and go through this, but it is possible they're doing it that way. Hi, Peter. My wife loves your show, which means I have to as well. Today is our wedding anniversary. Not guilty would be a great way to help us celebrate. Go Team Karen. Well, happy wedding day to Maxwell Butler and his wife. I say leaky balloon not 3 to 5 times a day in a row. Oof. I don't say it ever. How can they find her guilty of DUI when it's possible she could have been drinking? It is possible, but just like anything else, right? Just like anything else, if they don't see any of those possible doubts as reasonable doubts and they find that there was enough evidence to convict beyond a reasonable doubt, then they convict. Charlotte, all the fangirling in EDB's chat with both of you. That's crazy. That's crazy. Although if I was going to say there was a celebrity, I'd be in the same sentence as ever, it being John Stamos, a.k.a. Uncle Jesse, a.k.a. a Greek man. He would be probably on the list, right? I would not have guessed it would be both of us being in Emily D. Baker's chat at the same time, though. I found Laura, during Boone, which led me to EDB by proxy. I love you both equally, but different. I think that's a great explanation. Raven, Peter, thank you for all your hard work covering this trial. Love from Glasgow, Scotland, pronounced Glasgow. So I've been to Glasgow, actually. So I knew it was pronounced Glasgow. I still want to always say Glasgow, but Glasgow is appropriate. I agree with you. And the golf is amazing out there. The golf is absolutely amazing. Thank you, Mika, for gifting a membership. Let me check here the feed and see if I've heard from my dad. I got nothing on the feed. Let me check Twitter here. Let's see what we got. Anything on Twitter? I'm not seeing anything exploding there. I'm not seeing anything on the live court feed. All right. So I don't see anything there. Was it a mistake to add OUI on count 2 if that hangs all? I mean, sure, you could call it a mistake, but there are so many other dominoes. It's like the butterfly effect. If you change one thing in the past, how's it going to affect the future? I would tell them, which they wouldn't care what I had to say. I would tell them, don't lose sleep over it. They battled hard. They made so many tough decisions. So many of them worked amazingly. You're never going to have a perfect trial, right? It's a living, breathing thing, as my dad says. If guilty of OUI, but not guilty of manslaughter charges, can those be used against her as aggravating factors for OUI, or is that not a thing? No, they would actually have had to find not guilty on those above. So you cannot be punished for something that the jury finds you not guilty of. If they don't think she hit him, but they can't decide on OUI, can it just be hung on OUI? So we've kind of hit this. It would be hung on the entire count too. I got to do more research on that because it really doesn't make sense to me that you can find not guilty on a criminal charge and then be retried for it later. That's double jeopardy. That's not constitutional. It does not make logical sense to me. But at the same time, I kind of understand how people are saying it is in Massachusetts. I need to do more research on it. Although I want this verdict ASAP for the sake of poor Karen, I'm definitely going to miss your insight. It's been fun. We will still be here. We will still be here. Come hang out. Check out some other cases if they tickle your fancy. If not, just come to hang out. Mego, Peter, are you planning on following Corey Richins? Yes, I am. I've done some on her. The trials are by far the most fun to me. That's where I cut my teeth. That's what I like to do. So that's what I like to cover. How can they charge her with OUI without breathalyzer blood test? Well, they have a blood test and field sobriety test. So they have a blood test that they do the reverse extrapolation. I understand why people take issue with that, but they do have something to point back at. And also her driving and her statements, I think, are two of the things the jury's probably considering at this point. Can she change her plea to guilty only on the OUI? No, that's not something that the Commonwealth is offering at this point, as far as I know. Peter, court could make the slip understandable in a split second to avoid the same train wreck as last time. History is repeating itself, no responsibility. If she was going to do it, I would assume she would have done it by now. Do you think it's appropriate for the jury to negotiate? For example, completely not guilty. Do you agree to OUI to not being hung? It happens in a lot of juries that they negotiate with each other. Hi, Peter. Hey, Peter. First super chat. Love the show. Great questions from the jury. I still think they will be back today. Not guilty for sure. Unfortunately, no justice for John O'Keefe. Any reason Bev would deny polling the jury if hung? I can't see a reason why not. Why not get more information? Like and subscribe, peeps. Yes, please do. My dad was not able to make it back on. We're going to have to wind it down now. Kayla, I will finally answer your question. But if we have a verdict later today, which I think is very possible, I will try to jump on and bring my dad on to do a live reaction. So make sure you guys come back. Make sure you're subscribed. Make sure you've hit that like button if you haven't already. And if we do it tomorrow, I'm still going to try to bring my dad on to actually do a live Q&A with you guys. But whenever we have live court going on, you never know what's going to happen. And I know you wanted to watch that. So we decided to do that instead. He was able to answer a few questions, but I really want to just open it up for you guys to be able to ask him whatever questions you want. Michael Easter, the retired FBI investigator, the defense hired, that Bev denied, did an interview last night. He had a lot to say for both sides. Interesting. Kayla, curious if you both think a verdict is more probable than not today. Also, shout out to my husband, Kevin, who watches with me sometimes. Shout to Kevin Mahoney. I would guess a verdict by the end of the day today. That would be my guess if I had to put money down. But as I've said, kind of from the jump, I thought midday today was most likely. The very latest would be tomorrow, I think. And if they're not done by tomorrow, I think it's a hung jury. I've also heard they will come back in court on Friday and just miss Thursday. So I don't know if that's true. Judge Bev needs to be the smartest person in the room. That's why we are here. Maybe a quick video on the Baldoni dismissal. It's possible. Right now, my brain is kind of fried with this YouTube stuff. And I'm also prepping for a trial. I've read like 8 depositions in the last 2 days. My eyes are starting to bleed a little bit. Judge Bev needs to be the smartest person in the room. That is why we are here. I read that one twice, not intentionally. Peter, although I celebrate your success of more subs, I honestly can't wait for the riffraff to thin out so us OGs can have normal discussion without trolls. Please ignore them. Takes away from us. I think they're a very minor part of the discussion. Just pop over from EBD. Can't take insane chat speed when court isn't in. Yikes. Wishing you all had a tag team. This verdict. Watch. Love you both. I would love to hang with her and talk to her about this case. It's always interesting. Love hanging out with her and so many other people on YouTube generally, but it is always fun. Where does the defense go while they wait? I think they're in Yannetti's office is what they said. Okay. That's it, folks. That's all I got. I have a little bit of work to do here between now and 4 o'clock. So hopefully the jury doesn't come back before then. If they do, I will try to go early and I can just do my work tonight. But we will see how that all rides. I appreciate you guys so much for being here. I appreciate you hitting the like button, all your comments, all the chats, everything. I love talking about these cases with you, and it's crazy that it seems like we're coming to the end. And I hope we actually do get a verdict here in this case. Isn't the O'Keefe's wearing blue witness intimidation? I don't think so. I don't think so. Okay, that's all I got. Till next time. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.